Well, good morning. We'll wait a second while everybody joins. Great to see everybody joining us today. So we'll give it a couple minutes as we let everybody filter in and join. We've got great attendance today. So lots of people hanging out and thinking through all these things, RIF and non-renewal related. Ellen, it's almost like this might be an important topic for everybody.
And there's lots of names that I'm excited to see on here.
Yeah, very good. I know David Braun's going to be joining us shortly, so he had a little technical glitch this morning. He's going to get with us as soon as he can, but we're going to go ahead and get started here in a second, and David can join us when he does. But I'm Brandon Wright, a partner here with Franczek. I'm joined by my colleague Ellen Luking, and we are soon to be joined by David Braun, and super happy to be able to think through and talk through a lot of different issues as we are in that season to think about RIFs, dismissals, non-renewals, and all the things related to that. So, we're going to spend about a half hour or so together today to think through and talk through those issues. We've got the chat here as an option if there's questions for you all participating. So we'll pay close attention to that as we go through things. But we've kind of got our five or six big pressing questions we want to think about today. So Ellen, you want to kick us off and kind of see where we want to start the conversation?
Yeah, I we've been getting tons of questions about dismissals and RIFs. It's a hot time of year. And Brandon, if I recall correctly, there's something that everyone should have already done in February. What is that?
Yeah, so I'm making sure that our seniority lists, our sequence of honorable dismissal lists, I mean, that timeline for that might be coming up around now too. So, we're getting close on those windows to make sure we're updating all of that stuff. So if we are anticipating, reductions in force this year on the non-cert side, we got to have had that seniority list out already at this point. And on the teacher side or the PEL side, that's got to be out the sequence of honorable dismissal list 75 days before the end of the school term still. So that timeline will be coming up here real soon, depending on when your last day of school is.
Yeah. And so we hear a lot about the word non-renewal, particularly when we're talking about our Pell folks or professional educator licensed folks. Non-renewal has two meanings, right?
Yeah, yeah. I mean, I think we've sometimes used that term non-renewal as just a euphemism to soften what is maybe really a dismissal, right? So, we've got two types of dismissals that we want to think about today. One of those is a reduction in force or a RIF, where we're laying off staff, dismissing staff, not because of a performance issue necessarily, but because we are reducing the number of employees or the number of hours for employees, and so we just need fewer staff. It's about reducing positions, and obviously, when we are reducing positions, that impacts people. I think the other part that sometimes complicates that for us is that because on the teacher side, RIFs are and RIF groupings are tied to evaluation ratings. We've complicated that by sort of mixing those considerations together for us. But the RIF is really that elimination of a position because we don't need it anymore. A non-renewal is really just a nice way of saying we are dismissing for cause, right? That we are not renewing your contract for next year, and that is effectively a dismissal for cause. And those have different implications, whether we're talking about teacher, non-teacher, certified, non-certified, in that regard. But I think that's a big picture. David, we're just starting in on that first question, sort of that difference between a RIF and a dismissal. So I know you heard a little bit of my answer there, but anything else you want to weigh in on in terms of, that particular piece to things?
Yeah, I think where we get confused a lot is the statute in 24-11 and 24-12 uses that term non-renewal both times, which is really confusing. So for that reason, I always say If it's 24-11, non-renewal of a probationary teacher, it's a dismissal. If it's 24-12, it's a RIF, a reduction in force, or a layoff. There's nothing in the statute that says you don't have to have cause. There's only been an interpretation that we don't have to display cause for a non-renewal in 24-11, but we still have to decide whether we're going to afford them recall rights or not. And for that reason, it is always my advice that we decide what the cause is before we pick which one we're under.
Yeah, and
How do
I
we
think that
decide
you,
that?
you mentioned, yeah.
Go
Well,
ahead.
one other point there I want to make, Ellen, real quick before we get to your question is that's the other really important difference between a RIF and a dismissal, right? Or is that recall right piece. And so, back in the old days when I first started doing this 20 some years ago, that distinction didn't matter a whole lot because back in the olden days, non-tenured teachers didn't have recall rights in the same way that they do now. And so I think historically, and for those of us who have done this as long as David and I have, back in those days, we didn't care about that distinction as much because the legal impact of that was very different. But with the change now, 15, 16 years ago, creating a change in how we do RIFs and giving recall rights to non-tenured teachers potentially, now for the first time 15, 16 years ago. It's been that for a lot of your careers but that is also an important distinction and why we want to make sure which statute are we operating under? Is this somebody we don't want back, or is this somebody who we don't have a position for right now, but if we did, we would give them recall rights? So that's the other important distinction.
And I think sometimes we're a little conflict averse and we say non-renewal and we talk about RIF, and that's really not what we intended. We don't have any intention of bringing that employee back, and I think it's important that we operate in that manner if that's the truth. So back to, where do we find cause? How do you decide that?
Well, obviously, the evaluation is the most important piece of that, right?
I love how David explains cause. That's one of my favorite things in
So,
evaluations and good evaluations.
yeah, so what I look for when I look at what I look for when I look for cause is uh, I'm going to look at the totality of what's going on with the employee's file. But remember, we can't have illicit cause. I can't dismiss you because you're a woman or because you're a man or because you're over the age of 40 or you're disabled or pick your protected class. Just because I don't have to say what the cause is in the resolution does not mean I don't have to have cause. And to that end, the way I decide what cause is to my mind is, what do you have in writing that establishes what the cause is? Does the employee know that they're going to be dismissed, or do they have absolutely, is this going to come out of the clear blue sky? Every lawsuit I've ever had on a 1NT, first year non-tenured teacher, dismissal for cause occurred because the employee was surprised and said, well, I thought I was meeting your expectations. It's important in your as you draft. We can look at the evaluations. We can also look at things like disciplinary letters and those kinds of things. It's important that we are distinguishing why we're getting rid of you from some other cause they might make up. So, to my mind, the important thing in establishing cause is it clear to an objective third party why they're being dismissed? If the answer is no, then I don't have a good defense for you. If the answer is yes, oh, it's very clear. Remember, the people who went to be judges, people who went to be arbitrators, look a lot more like Brandon and Ellen and me than they do like you, acknowledging that Ellen did, in fact, go into teaching. It does have a teacher background. But the reality is, these are people who, by and large, are not trained as educators. So if you have speak in your evaluation and it's not clear to a third party, I mean, if you were able to give it to your child and your child understands what went wrong, or your spouse and your spouse understands what went wrong without any additional conversation, that is sufficient to support a dismissal for cause.
I want to mention one other piece to this that's maybe a slightly different difference that is important for us to recognize when we're talking about RIFs versus a dismissal for cause non-renewal. And that is also the Open Meetings Act difference, because a RIF, which is really eliminating a position, even though there will be a person or people dismissed at the back end, is not something that is properly a closed session discussion, right? That is talking about, we are eliminating, three elementary teaching positions this year. And even though that might end up being specific people who are going to be dismissed as a result of that, that's really about budget planning and positions. And that's got to be an open session conversation. We can't talk about the decision to RIF, generally speaking, in closed session. Whereas the decision to dismiss for cause, right? Obviously, you are talking about the performance and dismissal of a specific employee, and that is something that could be discussed in closed session. So I think when we talk about those two, there's also a very important Open Meetings Act difference in terms of what you can and can't discuss in closed session. And frankly, also an important difference between exactly what goes on your agenda in terms of whether it's a reduction in force dismissal or whether it is just a dismissal. And I think that that's another consideration we want to keep in mind.
I think there's another distinction we need to make right now because I've gotten this question at least 3 times this week. Dismissing ESPs. Is there a statutory right to dismiss them in the same way that we dismiss teachers who are early in their career?
This is one that I think that we sometimes overlook because not every district has the same provisions when it comes to what may or may not be a probationary period for those employees. For teachers, the probationary period during which, they have limited continued expectations of employment is set by statute. But for our non-certified staff, our ESPs, their probationary period, to the extent it even exists, is not set by statute, but is set by local policy or collective bargaining agreement. And so if you have a probationary period for non-certified staff that is 90 days, for example, and you get outside that 90 days, now we're getting into a situation where dismissals for cause may require a little more due process, right? And we need to look again to our bargaining agreement and our specific local policies for exactly how much process and what that process looks like, hearing or other things. But it's important to understand the extent to which your ESPs have a probationary period, because not every school district has designated by policy or collective bargaining agreement or probationary period for your non-certified staff. And if you don't, a dismissal for cause is going to require a certain level of due process. That's more than we might consider for teachers. And then realize the RIF process for ESPs is a different timeline, but also may be impacted by CBA.
And I think it's important to recognize that while we can do these by resolution at a date certain in the future, because a non-tenured teacher, probationary teacher, has a 1-year contract. They're not an at-will employee. They have a 1-year contract for each year they're in their probationary status. For a non-certified employee, their reasonable expectation of employment is a function of whether there's a collective bargaining agreement, whether there's a policy, what the totality of facts are. So if we're looking to dismiss a non-certified employee at the end of the year, that may not be something that is consistent with their reasonable expectation of employment. And so there's nothing that says you can't cut it off at the end of the year, but there's no resolution that does that sort of automatically in the way that we can do that with a first-year non-tenured teacher. Therefore, if you're going to cut off that expectation, you probably have to afford them some degree of due process. Now, again, to echo what Brandon said, how much that is a function of the contract and the facts on the ground. But there's a case, Grigsville Perry versus IALRB, which holds back in 2015. The Illinois Supreme Court held that if somebody has a reasonable expectation of continued employment, which is a function of the totality of the facts, including whether they got past a year of employment without further action of the board, then they're entitled to some cause for dismissal and appropriate things for due process, including hearing, a right to confront the evidence, and notice. And that would mean that they have to be dismissed for something, some cause which is neither arbitrary nor capricious.
Okay. Let's talk about the changes to the tenure statute for just a minute. This year is kind of an important year because this year is a year where we're starting to see the big impact of that change. What have you guys seen?
Yeah, I mean, remember, right? An important reminder, hopefully, for everybody listening and hanging out with us today, is that, the statute changed a couple years ago that created a different tenure timeline or timelines for those employed after July 1, 2023. And so, for those first employed in the 23-24 school year, they're on a 3-year tenure cycle as the default rather than a 4-year tenure cycle. And this is that third year. So we've got a lot of people who were first employed in that 23-24 school year for whom this is year three, which means this is the final probationary year, assuming they haven't acquired tenure already by virtue of getting two excellent ratings. So, somebody could have acquired tenure more quickly with two excellent ratings, including in 2 years, for those first employed in 23-24 and beyond. But recognize that this is the final probationary year. So, if in the past we thought about waiting till year four to make decisions about whether we're going to dismiss or not dismiss, and knowing in that final probationary year, we have to provide reasons in order for that dismissal to stick legally. For a lot of our staff now, this is the first year where that change is impacting, where those teachers who were not dismissed this year, who are third year teachers, they're going to enter into contractual continued service and have tenure after this school year.
And remember that with regard to the tenure changes, the notice deadline is now April 15th in the statute. But remember also that you may have a collective bargaining agreement that sets an earlier date. Can't set a later date, but it could set an earlier date, such as 45 days before the end of the school year, or even the statute used to say, and it's been a while, but the statute used to say 60 days before the end of the school year. And there are still a couple of contracts and or policies that sit out there that have that earlier date. So make sure you're using the earliest date that you reasonably can to get these notices out. Also remember that those dates have to be given that those are the dates by which the employee must receive the notice. And then finally, remember that we've got to change to the acceleration of tenure. And that acceleration of tenure is not just portable tenure, but also if you have two consecutive excellence, then you are tenured. And remember that tenure is not something we offer. I've had a lot of clients that came to me this year and said, well, we're not a portable tenure district, or we're not an accelerated tenure district. Well, tenure is a function of an operation of law. You don't get to choose whether or not you will comply with the statute. There's no right to say we're not going to honor that. You're honoring that whether you like it or not. And that means if you have two consecutive ratings, that person this year will be accelerated tenure, and that means that person is in their final year. Now, that does not mean they're already tenured if they've only got 2 years in the can, that is a year before this year and this year. However, it does mean you have to get the notice to them before April 15th, and it means that you have to have cause in the resolution. It's got to explain the cause to them about why they're being dismissed. And that's going to be a dicey situation where they've got two excellents. Explain to me what happened. Now, certainly, if you had an excellent evaluation rating and then they were criminally charged with something related to something that happened at school and you can independently prove it, that is a good reason to dismiss somebody with two excellents, notwithstanding that they're in their final year before tenure. But do remember, you have to be able to distinguish the cause.
I see a couple questions
I
here
was
in the Q&A. Thanks.
Yeah, I was going to pose one of these to you because I think it's a good question that follows up on something that we were talking about earlier. Um, how do you create one of those probationary periods that you guys were talking about? What process does that go through?
Well, I mean, for most of us, right, that's going to be done. That's going to be a mandatory subject of bargaining, and would be something that would be done through your collective bargaining agreement. If you have employees who are outside of that, I think that there's a way to do that by policy when there is not a collective bargaining agreement. But I think that would be the way typically to do so.
Yeah, I think I really appreciate when Ellen is giggling as she's posing the question because she knows we're headed for trouble here.
I knew someone was going to jump all over. That's a mandatory subject of bargaining.
Yeah, we've got the mandatory subject of bargaining. I agree that the policy that where there's no bargaining implication, we can set it by policy, but look out for that because to the extent that we had set really broad probationary periods that attempt to set cause as throughout the period, as no cause is the basis throughout the period, we're running directly into the court's decision in Grigsville Perry. I think 180 days is probably viable in policy, although it may create a bargaining situation where one doesn't presently exist. But if you get longer than that, you're running into whether there's a reasonable expectation of continued employment. And I don't think we can overrule the court by simply repolicying.
I have
I know we have some other questions in here that we can get into the weeds on sort of the resolutions and the way to
a,
deliver those things. But we do have a question here that's on a bigger topic that I think we want to make sure that we address before we run out of time today,
yeah.
which is administrators. So, the question is, do any of these rules apply to administrators who are not on a multi-year contract? And the answer is sort of. Yes and no, because there's some additional rules,
Right.
and so,
Reclass.
there are some additional rules in the school code for reclassification of administrators with different timelines, hearing rights, and notices for that. And so I think we have to recognize that there are uh, you know, by statute, especially principals and assistant principals have a right to reclassification if their contract as an administrator is not being renewed, which means reclassifying them back into a teaching position for which they are qualified. If they have underlying tenure in the district, then that is probably the way it will go, right? That they're not being dismissed as an employee, but they're just being reclassified out of their administrative position. If they don't have underlying tenure, then it is possible to reclassify and then dismiss them as a probationary teacher as well. But all of those timelines and processes are going to apply in addition to the timelines and processes that apply for administrators.
And be alert that there are multiple hearings that occur with that. And the statutes were written at one time together and then they separated and the legislature did not see fit to update both statutes at the same time, so they no longer match. So you have to have, for reclassification, you've got to have an initial resolution to propose, then a private hearing, then a public hearing. If you have somebody who's on a multi-year contract that they've waived tenure during the term of that contract, but not after, then you may be able to reclassify them into the classroom and then dismiss them as a probationary teacher. But be aware those timelines kind of run into each other because while you only have to start the reclassification process before the April 15th deadline, you have to conclude the dismissal process before the April 15th deadline to remove them as a non-tenured teacher. We've had a long discussion in the office even about whether you could start the process on the reclassification and finish the process on the dismissal beforehand. Obviously, if you've got time, I'd rather you do the whole reclassification process than the dismissal process, but there is at least a viable argument as the statute's constructed that you could start the reclassification process, make sure you complete the dismissal process, and then at the end of the reclassification process, you could reverse that dismissal decision. But be alert that those timelines are very strict in the statute and you have to meet them, and they're pretty early in the year. We're coming up on that reclassification deadline of April 1st.
That's right. And I think the other piece I just want to point out as part of that is the statute is clear that while an administrator cannot earn tenure during the term of a multi-year contract, they do not lose previously acquired tenure or tenure credit
Yep.
by accepting that multi-year contract. And I think sometimes that is a misunderstanding. And question here, does TRS versus IMRF matter? Yeah, we're talking about certified people here, so people who don't fall within that PEL administrator piece. We're talking about principals and assistant principals. superintendents and other certified administrators generally for those rules. For those non-certified administrators, those people who are, might be a director of transportation or someone else who doesn't have a professional educator license, their process is going to default back really to what's in their employment contract. And then, just additional basic employment law considerations like due process.
So one more time, just to summarize, if we are non-renewing a principal, it's not as simple as just telling them that their contract is not being renewed. There's a process we have to walk through with resolutions and an opportunity for a private and a public hearing, right?
That's right. Now, the private hearing and the public hearing are only if they're requested, right? So,
Right.
I mean, that matters. Um, but that right is there. And I think just I see in the question in the Q&A to clarify, you can or should reclassify an assistant principal without tenure. The answer is you must reclassify, but then you could also dismiss them because they're a non-tenured teacher, right? So that's really the way that process would work. They still have that right
If
to
you want to,
reclassification.
there's nothing that requires us to reclassify anybody if we're looking to remain for them to remain in the position. But if we're looking to remove them from the position, the statute now says you have to reclassify. It used to say only for somebody who'd been there 2 or more years. It now says any assistant principal or principal with any length of contract has to be reclassified before you can even contemplate dismissal. That is, you take them out of the principal position, you return them into the classroom. Now we get to make the determination, are they a non-tenured teacher that can be dismissed, or are they not a non-tenured teacher and they're going to be staying in that classroom?
Can we do just a very general walkthrough of the process for dismissing a, PEL? Just from a overview of, we have resolutions, we have
A
notice.
probationary
A
PEL?
A probationary PEL.
Yeah,
Yes.
if we've got a non-tenured teacher, a probationary PEL, ultimately what's going to be required here is that let's take two different examples. Let's say it's not their final probationary year, and then we'll talk about if it is their final probationary year. If it is not their final probationary year, then we have to have the board adopt the appropriate resolution, and then give them notice of that decision by the ways required by the school code, which is generally personal service and certified mail, and make sure that they get it no later. They have to receive that notice no later than the statutory timeline, which is April 15th, or an earlier date if that is the date in your collective bargaining agreement. So really, for that probationary teacher that's not in their final year, it's a matter of the right resolution being adopted in enough time to give them the notice all the ways that they're required to give their notice. The piece we would add to that answer, if it is their final probationary year, is that resolution and notice has to include the specific reasons for their dismissal within that resolution and notice.
Excellent. We do have another question. What are reasonable timeframes for the district putting a deadline on reclassification requests for hearing? And if I'm not mistaken, I believe that those are outlined in the statute
Yeah,
as
they're
15 days.
Yeah, there are statutory timelines that they've got to be afforded, and we can't shorten those statutory timelines. I think it's 10 and 5 in the statute, or maybe it's 15 and 10. I've forgotten off the top of my head. But in any event, there are statutory timelines for them to be afforded sufficient notice before that they can be forced to waive the hearing. What I always do just in my process is to send them a standard waiver and say, if you want to waive it, here's the deal. I'm scheduling that private hearing. In fact, when I draft the resolution, I always put the date of the hearing so that they know that the last point at which they could effectively remove that private hearing from the agenda. One thing that I do want to make sure that we're watching out for is whether the person could rescind the waiver, because it is sometimes true that somebody will say, "Oh, I waive," and then 5 minutes before Oh no, I don't waive. And we've got a detrimental reliance issue there. So most of the time we're not now having the hearing, but we should be alert to whether that waiver is irrevocable. So again, there's sort of magic language that we use when we draft these things to make sure everybody understands what's happening next and what rights we're giving up.
I know we're getting close on time, but I see two important questions in the Q&A that I want to make sure that we address, which is one, the reclassification rules and those timelines are specific for principals and assistant principals, and for other administrators, like a superintendent, like an assistant superintendent, like a director of special education, if they're not a principal or assistant principal, those reclassification rules don't automatically exist. The timeline for giving them notice of non-renewing their contract and those pieces are still there. We often follow a very similar process, but the reclassification piece is unique to principals and assistant principals. So but I will also note that sometimes boards have granted those rights by contract. For example, they use a principals form contract for another administrator that has that language or cites to that section of the school code in it. So beware of sometimes we've inadvertently or sometimes intentionally provided those additional rights to other administrators. The one other question that I see here is what if somebody doesn't have a PEL, like a sub license only? And I think that's another important point to realize that in the statutory changes that took effect a couple of years ago related to tenure is that you must have a PEL or a couple other exceptions like CTE licensure and those kinds of things um,
Or
in
provisional
order
CTE
to,
license.
yeah, for those years to count. So if I'm a sub license only, those years aren't counting towards tenure. They may be counting for seniority or salary schedule or other things based on your local bargaining history and practices, but you got to have a professional educator license or the other exceptions that are there for us in order for those years to count towards tenure.
And I wanted to note that when Brandon chose his language very, very carefully there. If they have a sub license only, not if they are subbing only. Those are two different things. If somebody has a PEL and they're in a substitute position, they're in a roving sub position on the basis of endorsement, they are still earning time toward tenure if they are a PEL employee operating in a PEL required position, regardless of endorsements. So be very careful. And by the way, a lack of necessary endorsement may be a basis for dismissal as a non-tenured teacher, probably isn't as a tenured teacher, but be careful about how we work through that process, that we're looking at people accumulating tenure on the basis of licensure, not position in which they're situated exclusively. Boy, we covered a lot of stuff in 30 minutes.
We did, and
There's
counting.
one super interesting question that I'm actually very interested in how the two of you would answer this.
All
So if
right,
you
we'll make
don't
it our
mind me
last question.
tossing one more.
All right, one
Okay.
more question.
Okay. Principal or AP going through the reclassification process, are they placed into a grouping list? Because in a small district like ours, they may have seniority in positions that they qualify for. How would that impact a reduction in force?
I'll start, David,
Yeah.
unless you
Go,
want
go,
to.
go, go.
I mean, I do think it is generally good practice to have your administrators on your sequence model dismissal list potentially, right? But especially if we get to that point. But I think that the grouping list starts to then conflate, is this a RIF or is this a dismissal non-renewal? Because the grouping list only matters if we're eliminating a position and we're doing it as a RIF rather than as a probationary piece. So if they're tenured and we're reclassifying back into a classroom position and we don't need that extra person and there is a RIF, then that RIF, it may or may not be the administrator because there may or may not be the person based upon the sequence of honorable dismissal list who would be the person without a chair when the music stops. But that only matters if that's a RIF versus a dismissal non-renewal.
Yeah, I have taken the position always that they're on the groupings list. They're license required individuals. They have license. So I think they have to be on the list because in the event there's a RIF, we have to contemplate the groupings assignment. But agree and want to echo what Brandon said about we need to be careful that we're making decisions on the basis of RIF versus cause, because to the extent there's a cause-based decision, the RIF list, the groupings list is effectively irrelevant. On the other hand, in the event we're reducing an administrator and or we're dismissing an administrator who's got tenure, reclassifying an administrator who's got tenure, then where they fit on that groupings list is going to be critically important, because you can't dismiss them for cause without going through a tenure teacher dismissal process. And assuming you don't have sufficient cause for that, where we're really headed is to move them back to the classroom, and that may result in bumping a less senior teacher out of their position.
Okay, well, we have far exceeded our time by
As we tend to do.
But that was because we had some really great questions. There exist questions still here that we simply don't have time to answer, or they require so much nuance that they are better suited for contacting your attorney directly. So please feel free to do that.
Well, thanks everybody for hanging out. Thank you, Ellen and David. So great to see you guys as always. Happy to see so many friends here participating and listening today. Happy almost March. Happy almost Casimir Pulaski Day. And
Thanks
good
everybody
luck.
for coming.
Yeah, we'll talk to you all soon.
Thank you.